Hello, my name is William Craig. As many of my family and friends are aware, I had my oral argument with the Tennessee Court of Appeals this morning. And for those that have had the opportunity to watch, you can see where the Court of Appeals has excluded most of the sound during my portion of the oral argument. I don't believe this was a technical error or a mistake, as the portions of the court has excluded were specifically my issues raised on appeal, which are the issues I'm trying to get the Tennessee Court of Appeals to address in their issues, in their final opinions in my case. To ensure I receive a just opinion, I need the courts to acknowledge all of the issues I've raised in my appeal. And to do so, I'm requesting as much support from family, friends, fellow Tennesseans, and all supporters of justice in this great country. The following is the oral argument I had intended to be heard this morning. Also, please watch the oral argument posted with the Court of Appeals and keep a lookout for a final opinion in my case. Thanks for watching. My oral argument. Good morning. I, William Craig, stand before you representing myself. This appeal concerns a divorce proceeding and my motion to recuse Knox County 4th Circuit Judge Gregory McMillan. I want to start off by conveying to the courts today that the appeal process has been a long and hard one for me, involving a significant amount of paperwork for what should have been a straightforward appeal, especially given the quality of the numerous filings I made with the lower court and the fact that I was benefited with electronic recordings for my transcripts. Electronic recordings are uncommon in East Tennessee courtrooms, so I am fortunate to have this evidence, since I can attest to the fact that I would not have been able to afford a court reporter or the cost of paying to have the official transcripts produced. These recordings provided by the lower court provide clear audio and video of my full hearing and leaves no questions as to what has occurred in my case. As this court is distinctly aware, the present issues I've raised on appeal and that warrant this court's urgent attention are as follows. First, I am arguing that this court should reverse dismissal of my motion for civil contempt due to Ms. McCabe's failure to comply with a valid court order. I contend that Judge McMillan overstepped his authority by rendering a valid order null, since the order was signed by him and had a certificate of service issued by the courts. When a legitimate contempt petition is dismissed, it indicates that proper court processes are not being followed. This not only hinders the pursuit of justice, but also questions validity and purpose of judicial system itself. The issue is thoroughly addressed in my brief. Next, I assert that Judge McMillan abuses discretion by appointing an attorney for Ms. McCabe during these divorce proceedings. This appointment was in reaction to my motion for civil contempt, even though Ms. McCabe could have resolved the contempt charge by adhering to discovery requests and court's orders. According to Tennessee Code 40-14-102, it's not permissible for a judge to assign a court-appointed attorney in such a context. I've extensively elaborated on this issue in my brief, where I provide supporting evidence from the record. Additionally, I contend that this court should vacate and remand for entry of a new permanent parenting plan due to Judge McMillan's abuse of discretion when he assigned Ms. McCabe as the primary parent and sole decision maker of our sole child. It is evident that Judge McMillan's decision was not in the best interest of my child in consideration of the testimony and evidence of Ms. McCabe's parenting history for her two older children, which conflicts with Factor 36-6-106. Additionally, Judge McMillan failed to properly weigh the evidence presented at trial and the record as a whole for Factor 36-6-106, which is covered in my brief and cited to the record extensively. Furthermore, I submit that this court should reverse the child support amount calculated by the trial court judge. I am arguing that he abused his discretion when he assigned me an income while ignoring what Ms. McCabe did not provide any income documents for calculation of child support. Prior to or during trial, Ms. McCabe's income was clearly proven in court, and yet Judge McMillan still did not acknowledge her business income, her earnings ability as a registered nurse, or the evidence of personal income. This issue is thoroughly addressed in my brief as well. Next, it is imperative to address that this court should reverse the decision to assign 75% of the costs and fees to me in the October 11th, 22 final order. Ms. McCabe is the party that filed the complaint for divorce, yet failed to amend her divorce complaint. When she filed motions to void her marriage, my brief and other records covers everything extensively, and your honors can see where Ms. McCabe did little participation in the trial court as well in her appellee brief. Her brief is clearly not a viable brief since it makes no reference to the record on appeal and isn't even labeled correctly. Additionally, the lower court is supposed to consider the following factors when assessing court costs, such as the ability of each party to pay, the respect fault of each party in causing the divorce, or if either party was responsible for prolonging the proceedings. Based on the evidence in the record, I am arguing that Judge McMillan showed clear bias by assigning 75% of the costs and fees to me. Next, the most important issue I have on appeal is that this court should vacate the erroneous August 12, 22 order that voided my marriage to Ms. McCabe. It is clear that Judge McMillan's decision to void my marriage is not allowable based on Tennessee Code 363102. To be clear, Ms. McCabe falsely claimed that I was still married to a Miss Amy Boring, even though I have had 2 marriages since marrying Miss Boring in 1992. Judge McMillan initially entered an order on February 4th, 22 that established my marriage to Miss McCabe as valid, citing the existence of my prior marriage and divorce from Rashida Shabazz. However, in the August 12th order, Judge McMillan ignored my marriage and divorce from Rashida, and he refused to acknowledge Exhibit 1 in his August 12, 23 order, which was Amy Boring and her current husband, Robert Wells' marriage certificate. These actions allowed Judge McMillan to ignore the relevancy of Tennessee Code 363102. Since neither myself nor Miss Boring had known if the other was still living since April of 1992, we both remarried in the year 1998, which was well within the parameters of Tennessee Code 363102. This Tennessee Code clearly states that a second marriage cannot be contracted before the dissolution of the first, but the first shall be regarded as dissolved for the purpose if either party has been absent for 5 years and is not known to be to the other living. Therefore, according to Tennessee Code, my marriage to Amy Boring was dissolved prior to her marriage to Robert and my marriage to Rashida. Extensive proof that I am not currently married to Miss Boring and that she is married to Robert can be found throughout my motion to recuse, and the record is whole, which is extensively covered in my brief. Additionally, to have my valid marriage to Miss McCabe voided erroneously has left me in a perpetual state of confusion as to whether I am truly divorced, what's my rights as far as remarriage, and long-term financial implications. This court must vacate the decision to void my marriage and grant me a true divorce. Lastly, I am arguing that this court should reverse Judge McMillan's denial of my recusal motion because Judge McMillan showed clear bias and abused his discretion throughout the case. As the record in my motion to recuse clearly show, Judge McMillan entered orders and took actions that violated Canons 1 and 2 of the Tennessee Code of Judicial Conduct. My recusal motion consisted of 37 pages and 52 exhibits, and the order denying my recusal motion consisted of only one page that said nothing to thwart my claims. Judge McMillan's response was that I didn't do the motion to recuse properly, and even went so far as to say that my motion lacked the required statement, which is blatantly false. Your Honors can see the referred to statement that this motion to recuse is not being presented for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. It's clearly in the first paragraph of my motion. To recuse, thereby invalidating the denial of my recusal request, this imperative issue is thoroughly addressed in my brief as well. I have worked extremely hard to provide this court with an extensive record consisting of 12 hearings, of video transcripts, and a technical record consisting of over 1,200 pages. The amount of work I poured into this case is indisputable, as the record speaks for itself. With that said, it is my right to receive a comprehensive opinion from this court addressing each issue I've raised on appeal. It is alarming to me that only the court's final opinions are made publicly available online, while the briefs which raise the issues are not. Since the public cannot view the issues raised in my brief, this creates room for bias and error, and is one of the reasons I'm participating in the oral argument today. I want to ensure that each issue I've raised on appeal is formally acknowledged and that I receive the opinion I'm entitled to per the court rules. I'm very confident in my brief and its ability to stand alone, especially given that the appellee has not submitted a viable brief because her case simply has no merit. Ms. McCabe has no evidence to cite in the record, as her entire case has been based upon unfounded accusations. I also want to point out to this court that Ms. McCabe never presented any meaningful evidence to the lower court, or even once questioned me during any of the 12 hearings that were held. One other notable point of contention is that I need to bring to light here today is that in addition to facing delays in the trial court submission of a partial record to this court, I also experienced significant difficulties obtaining my full record for this appeal. Although I eventually secured certain documents, like my parental education certificate, to this day my full record from the trial court has not been sent to this court. Having said, I would be disappointed if this court were to cite anything in this opinion that was requested by me to be either added or omitted from the record. I would also like to point out to the court that if you look at my public case history, you can see many motions to supplement the record, proving the existence of said trial court documents by attaching them as exhibits to my motions. However, in my online public record, you can see my motions to supplement have been both stricken and mislabeled as miscellaneous filings. Rule 24, to clarify, allows appellants to demonstrate extraordinary circumstances to help obtain missing items on appeal. Otherwise, the trial court's decision is conclusive. I must say that it doesn't appear a fair process for a trial court judge to deny a party's motion to recuse and then that same judge to be allowed to decide what is kept in and out of the party's record on appeal. This is especially egregious when the denial of a judge's motion to recuse has been raised in an issue on appeal, such as in my case. Moreover, I would like this court to realize that I have submitted over 30 motions, notices to this Court of Appeals in a year. In contrast, Ms. McCabe, the appellee, has only filed 2 documents, a request for an extension and her brief, which was labeled Appellee Brief and motion to dismiss. This brief motion to dismiss does not reference the record at all, which as per this court's rules is a requirement for all assertions of facts made in an appeal. I expect the court to recognize and address this discrepancy in its final opinion. Furthermore, I want to draw your attention to the bridging order signed by Judge McMillan and found on page 1037 of the record. Notably, this so-called bridging order has not received approval from the Tennessee Administrative Office of the courts, and according to Tennessee Code, bridging orders are non-existent. Compounding this, Judge McMillan cites a Tennessee Code that merely provides definitions to support his bridging orders. These bridging orders appear to be fraudulent and should be concerning for all Tennesseans. I am compelling this court to investigate these bridging orders and address them accordingly. Lastly, I beseech this court to earnestly review my motions to recuse Judge McMillan. Again, this document spans 37 pages and 52 exhibits, providing a comprehensive account of the misconduct I endured in Judge McMillan's courtroom. My motion to recuse cites not only his misconduct, but also the oversight of misconduct by my attorney, Ms. Michaela Smith. He permitted her to file a motion to withdraw from my case, her sole filing, without her ever having properly notified the court of her representation. This is a violation of the codes of judicial conduct, as he was obligated to report her misconduct to the appropriate authorities. I firmly assert that Judge McMillan's courtroom is not a safe place for me to go back to, and I urgently appeal for the reversal of his denial of my motion to recuse. If this court vacates Judge McMillan's orders, but then remands me back to his court, thereby denying my motion to recuse, I will not be able to receive a fair trial. My brief recusal motion, electronic transcripts, and the record as a whole provided this court with extensive, irrefutable evidence that Judge McMillan is violating the fundamental court process and that he is biased against me. In closing, I want to say that I have the utmost respect for the appellate process and our checks and balances, as without them we do not have a justice system. Therefore, I earnestly request in this court to meticulously review my case, taking resolute action to ensure accountability where it is due. Thank you for your time today.